Hi there and welcome to the show. I'm your host, John Ivison, and this week I'm joined by retired Federal Court Judge, the Honourable Peter Annis, who has taken the highly unusual step of publicly criticising the courts and the government, the federal government, over the new official languages legislation C13, which is currently before the House of Commons, heading towards the Senate, and due to go to royal assent before the end of the session. Peter, thanks for coming on. I'd like to give our viewers some background first about your concerns about the new legislation. You see it as a threat to national unity. You've written a paper on rebalancing bilingualism. And in your words, you say Canada may find itself in a Belgian-like relationship between two official language groups in open hostility to one another, or worse, in a relationship with a new country called Canada West. That's pretty ominous sounding. Let me ask you first, what persuaded you to break the unwritten convention that judges do not criticise other judges, particularly when it involves cases that they've heard themselves?
Well, for sure, it's not something that I wanted to do. There is an unwritten convention, and the reason that I decided I could not adhere to it probably is because the consequences of the Federal Court of Appeal decision are really very significant on the whole Official Language Act and how it's now proceeding. And as such, I do see real problems down the road once Anglophones understand what that decision stands for, and that decision also is very significant in underpinning the amendments to the Official Languages Act that's going on now. I'm a great supporter of Francophone rights. I have been all along. You look at my CV and you'll see that I've been there all along. And of course, I've studied the thing and I've acted for the Commission of Official Languages. So it really comes down, in my view, in protecting attitudes. And I think the Commission of Official Languages, the main role is to ensure that attitudes remain positive towards the two language communities. And I'm very concerned that because so much of this has gone on without proper transparency, that when Anglophones do understand the implications of the FCA decision, which maybe will never be really understood if it's not brought before the the Supreme Court, but for the extent of judicial amendments that decision made, it's really something that ought to have been gone before the Supreme Court, and it didn't. And I think ultimately, as Lincoln says, I guess you can't fool all the people all the time, and when it really comes out what the results of it, that decision is.
Well, let's unpack some of that. We'll get into the Federal Court of Appeal decision and what happened and what it's likely to mean.
But the bottom line is I did not want to do this. I felt compelled to be, and I had to.
And you didn't go public, really. I mean, you sent a piece that you wrote on rebalancing bilingualism to the Attorney General and David Lametti and to Provincial Attorneys General while C13 was before Parliament, hoping that something would be done, and nothing was done.
And this article is written for lawyers. It's a pretty heavy. The subject matter of official languages is complicated. There's no question about it. And the article was designed to be read by the Attorney Generals, and that they would then be able to make some kind of appeal to it, but nothing's happened, and I just think that the situation is such that in the long run, this will rebound to the disadvantage of Canada, particularly when the West. You're right. There's a degree of alienation out in the West, which is really strong, and I'm concerned that in the end, this could have ramifications at that level.
Well, let's get into some of this. The paper we're referring to, by the way, is linked to on the National Post website. You mentioned the fact that you're steeped in language legislation and have considerable sympathy for it. You wrote your doctoral thesis on it. You've worked as an advisor to previous commissioners of official languages. You've been a lifelong supporter of what you call balanced language legislation, which doesn't put the rights of one linguistic group over another. But now you think the government policy favours Francophone rights over those of Anglophones, correct?
I'm not sure it's the policy concept. The problem is that the Federal Court of Appeal decision has amended judicially much of the 1988 Official Languages Act, which I think was a spectacularly brilliant piece of legislation, well balanced, and Francophones have done very well by it, and Canadians remain very positive towards bilingualism, and so that it's something that you really have to be careful. You have to nurse attitudes, because once you lose attitudes, there's no going back on them, and if you don't have positive attitudes, then things don't work. If you do,
and you mentioned that Canada is almost revered as a model to the rest of the world of two linguistic groups getting on pretty well.
I don't see any other model out there for basically dealing with the problems of different languages, races, diversity. I think Canada is the model, and you need models. We need models, and we're it. That's how I see Canada. That's how important it is. It goes beyond. We have a duty to make things work in Canada, not just for Canadians, but I think almost for the rest of the world, so that we've got something that they can say, well, look to Canada. And the European Union is very much, it took its start to a large extent from Canada. We demonstrated that, yes, we could have two language groups, and we could find a way to work and have a degree of respect and a degree of consensual accommodation, not accommodation like it was in the old times when it was forced, but a consensual accommodation and reach. And what's happened is this has changed in the last little while.
So let's get into the meat of it. As a federal court trial judge in 2019, you presided over a case in which a bilingual francophone Montreal-based employee of the Office of the Superintendent of Financial Institutions, OSFI as it's known, sought to have the jobs of co-workers in Toronto redesignated as bilingual positions to allow him to work entirely in his first language of French. And this was not an argument that you found convincing. Why not?
Well, because it infringed the merit principle of staffing. The positions in Toronto did not require bilingual skills for the performance, and it's contrary to a specific provision, Section 91 of the OLA. That's number one. And the second thing is that we have unilingual regions, and Toronto is in a unilingual region, while Montreal is in a bilingual region. And the whole concept of unilingual regions, and this is really important to the West, is that they have that English is the language that's used out there, and in the unilingual regions. And the concept is that you're not going to have to create bilingual positions in unilingual regions because the Francophones who are bilingual and paid to be bilingual have these rights, and when it all comes back to what is of such concern to me is that it's based on an interpretive principle that's said to arise out of a Supreme Court decision, and the Supreme Court decision doesn't say what I believe the Federal Court of Appeal found, which is effectively that Francophone rights have precedence over Anglophone rights, and that's simply not the case. But that is the foundation, although you won't find it in their reasons, because there's a tremendous transparency issue in the FCA decision.
Well, let's get into the FCA decision. So this is the Federal Court of Appeal,
yes,
which looked at your decision. I guess it overturned your decision. Those jobs in Toronto were redesignated as bilingual jobs.
They had been redesignated already. The question is whether that was properly done. Yes,
right, and you claim that the appeal decision contained foundational errors, and this is really the nub of what you see as the problem and how it's flowed into the government's legislation, correct?
Well, this is legalese, but I tell you, some of it's really simple to understand. So on my decision, for instance, I'm all over merit. I use the term 59, I counted them up 59 times, and it's not found anywhere in the Court of Appeal decision. Section 91, which is this provision which stands in the way, you can't possibly do what happened in Toronto, because it indicates that you cannot impose bilingualism or language rights in a situation unless they're required to perform the duties of the position. And of course they weren't, and it specifically says that this provision has precedence over the language of work provision. So, and then on top of it, you've got the unilingual regions, which were just not mentioned at all in the decision as well. So the whole thing is that my reasoning was never even brought to light in the Federal Court of Appeal decision, and that's problematic because the fundamental concept is this is what he says and that's what's wrong, and And my sense is they didn't want to mention merit, because as soon as somebody says merit, well, how could merit be here? And merit would be upheld. It's all written all over through the OLA as well. And the same thing with the unilingual regions. It wasn't even mentioned. And it's the unilingual regions that's really my concern as well, more than anything else, because that in the end, what's happening is that unilingual Anglophone positions are being replaced by bilingual positions in circumstances where it's not supported by the merit principle, and it's contrary to the whole concept of upholding unilingual regions. So now, that's it in a nutshell.
You suggested that in the normal course of events, the Attorney General of Canada, David Lametti, the Justice Minister, would have and should have appealed that decision to the Supreme Court of Canada, and that the Supreme Court of Canada would have unearthed those foundational errors. He has not done so, whether that's got to do with the fact that the government was very keen to pass Bill C-13, its own amendment of the Official Languages Act. What do you think the two are linked? Do you think?
Well, let me just respond to that first of all. Okay, the problem is that if you read the Federal Court of Appeal decision, you would not know that merit staffing was an issue. You would not know that unilingual regions was an issue. They dispatched Section 91 in a four-line paragraph at the conclusion of their reasons, so you wouldn't know that Section 91 was an absolute block to what they found. And on top of that, they also indicated that on their own, with having no foundation for that at all, that two supervisory provisions would also have to be created in the unilingual regions to supervise the 13 new bilingual positions that are there. So what that means is that your career route is cut off as well, because you're going to have replacing Anglophones in the unilingual regions, and as well there's going to be supervisors who will be bilingual as well, and that's contrary to what unilingual regions said, and there's no foundation whatsoever to have appointed to require the two supervisors to be, just nothing anywhere in any act that you could ever find.
So,
all that flows into the amendments. All that flows into the amendments.
Right. So when you're talking about the amendments, you're talking about Bill C-13, and which in turn creates a new legislation governing the regulation of federally regulated industries, which applies to Quebec immediately, I guess, as soon as the legislation passes, and within 2 years to areas in English Canada that are deemed to have sufficient Francophone influence. And I guess the logic flows that when the people working for banks or airlines or communications companies in English in areas of English Canada, or I guess in Quebec, and they're dealing with co-workers in Calgary or Toronto or wherever it may be, the same logic applies, that they may push for those positions to be bilingual, therefore limiting the career opportunities for unilingual Anglophones. That's your fear, correct?
Well, there's a lot of fears, and really you have to read what I said about that act. But the problem there is that, as it stands now, the federal government is applying what I would call the Quebec model to language rights, in the sense that in the federal model, if you have two bilingual persons, each is allowed to use their own language, all right? In other words, if an Anglophone bilingual person is communicating with a Francophone bilingual person, they can each use their own language. In what way I read the business, the regulated, federally regulated Business Act, is that all communications have to be in the language of the Francophone. So that causes gigantic problems. I don't know how they're going to work it. But the other thing that I'm so concerned about that is that they're starting with the province of Quebec applying the same thing. It's supposed to protect the language of French in Quebec in federal institutions and in private institutions, and it's totally unnecessary, because that's all been taken care of course, by the Quebec government. And I may add, I have very little problems with the Quebec government and Quebec wanting to be as French as Ontario is English. So I mean, the way they've done certain things, I think they could probably change it. But overall, I don't have those issues with Quebec that some people do, because I think that they are in a special circumstances and they do have to protect their language. And I've always said that, and I say the same, even more so for the minorities in Anglophone provinces. But the problem is that when you get into these type of circumstances where unilingual Anglophones are going to be displaced without proper basis. I mean, everything that's been done up until the FCA decision was based on merit. The concept of Francophones providing services was based on merit. The concept of managers having to manage in the language of bilingual, that was based on merit. So, and it's just when they stepped off merit, and I said as plainly as I could in my decision, don't throw merit out the window. Basically that's what they've done. And on top of that, the unilingual regions. But coming back to the use of French in the, Federally Regulated Private Business Act, that's a mouthful if ever was, it's got so many problems, and I don't think it really has anything to do with establishing Quebec. I think the whole concept is to expand bilingualism into the private sector in Anglophone provinces. That seems to be what it is, and they're doing it all by regulations, which will be enacted sometime in the future, 2 years, and so nobody even knows what the regulations are going to be, and it's just the whole thing.
And we don't know the regions.
I've seen a piece of legislation like in my life. It's just bizarrest thing possible.
We don't know the regions in English Canada that are going to be deemed to be affected.
No. And also you're going to have committees that have to work with the senior committees and banks and things like that to ensure that the Francophone rights are, I mean, you're going to have the Commission of Official Languages involved in these businesses. I just say, wow, I don't think Anglophones really understand what's going on.
Well, I was going to ask you this because, there's been very little public angst in English Canada about Bill C-13, but obviously you're painting a picture that is pretty dark. Why do you think that is?
Anglophones just aren't interested in language laws. They're just something that they don't follow. They're hard to follow to start off with. And it's hard to speak up against them. I mean, here I am, I'm doing this, and I know all my Francophone friends say, how could you do this, Peter? And I'm saying I'm doing it because I think that it's more important that attitudes remain positive and that we don't have circumstances where they fall apart, and who knows what could happen in the future. Look what's happened in the United States since after 2015. Who would have ever thought the United States would have gone the way they did in the last few years? So it's the changing times, and so I'm saying no. The best thing is to have good relations between the two language groups, and don't abandon something like merit. Don't override unilingual regions, because you're really fighting with fire. And we have a separate sort of government out there in Alberta, and I don't know. That could be a chip in the window, as I say, that if you don't deal with ends up going right across the windshield, and you got to replace the windshield. So these are very difficult times now, and caution is what's required, and the role of the Commission of Official Languages is to promote good attitudes between the two major language groups. Obviously, the Official Languages Act was always set up to protect Francophones and to advance their interests, because they were discriminated against for such a long time. And I agreed with all that. But once they go off the path of what's reasonable and fair, I think that there's a lot of people out there who are saying, hey, we shouldn't have anything to do with this, and we don't want them coming forward. It's the 1988 Official Language Act was a thing of beauty, and Francophones have done very well. And right now, I'm concerned that it's going in completely the wrong direction. So that's what it comes down to.
Just finally, do you think there's a way out of this, a way that we could restore balance to federal language policy?
Well, number one is you have to get the FCA decision back in front of the Supreme Court, because what the FCA said fundamentally is that Francophone rights have precedence over Anglophone rights, which isn't true. I mean, in terms of assisting minority Francophone communities, which are I don't think Canadians recognize that a linguistic minority community includes all the majority of Quebec. So they should look at this legislation with that understanding, because it's not transparent at all. But the point is that the concept of any idea that in federal institutions, for things like positions, that one language has priority over the other is not correct. And the interpretive process that was followed by the Federal Court of Appeal, if you read my decision, and I'm hoping that lawyers and judges will read it, they didn't follow any of the rules, the interpretation rules of interpreting key terms. And by not interpreting key terms, they kind of made up what they wanted to do. So the whole thing is, and that's what brings me out. But I would have let it go, but when I looked at the amendments and I looked at the federally related business, I said, wow. This is beyond, and this is sort of the continuity, and somebody has to speak up, because Anglophones don't know the first thing about it.
Right.
And sadly, I'm the only person, or at least one of the few people, who I guess knows about it, because I worked for the Commission of Official Languages and did my work with Francophones as part of my job, and did my thesis on all that, and so I understand it. And there's Anglophones, as soon as you talk about language rights, their eyes blur a little bit, and they wonder whether Toronto's going to make it this year in the Stanley Cup, and to a certain extent.
Well, they
should wake up.
We hope that a few more people understand it after this, and we appreciate your candour, Peter. So thank you very much.
Thank you.